Welcome to the part 3, Types of Postmortem Examination and Practice MCQs in Inquest and Disposal of the Dead. To summarize part 1 and part 2, as you can understand, upon death, the first thing is to confirm the death. The next step is to find the cause of death and the manner of death. For that, we need sometimes the process called inquest procedure. Sometimes we should not have anything. The ward doctor or a doctor outside can give the cause of death straight away. Right? So if the process of inquest is needed, now we have to follow the law of the country, which is mentioned in the Criminal Procedure Code. Here, now who are the people that who is going to have the inquest? Either coroner or inquiry into sudden death or magistrate. So according to the powers that they are going to have, they are going to have the inquest. Now, if you think about the coroner or inquiry into sudden deaths, there may be instances where he is not going to order the postmortem to the JMO because he can release the dead body even without a postmortem examination. However, usually the magistrate is going to order the postmortem examination to the JMO. So, with the order, now a JMO or Judicial Medical Officer is going to do the postmortem. Now, with the findings, he is going to issue the medical cause of death. Now, this medical cause of death will go to the person who has ordered to him to do the postmortem. If the coroner is going to order, now he is going to give the medical cause of death to the coroner. And if the order is received from if the order gives by the magistrate, he is going to give the cause of death to the magistrate. By using this information, either magistrate or the coroner is going to give his cause of death. That means coroner's certificate of death or the inquirer's certificate of death. As you can understand, now cause of death and manner of death is known. The next step is to get the death registered. For that, relatives should go to the area birth and death registrar. Now, there are certain other ways that we can get this cause of death and manner of death and etc. As an example, area Grama Seva Niladhari or state superintendent, right? So now these people are not going to give the cause of death. However, they are going to report the death to the area registrar to get the death registered. Then now the area registrar of birth and death is going to register the dead body and then issue the death certificate. With this death certificate, relatives should go to the funeral directors and also to the urban council, municipal council or Pradeshiya Sabha to get allocated a plot for burial or to get the crematorium done. So now these are the basic steps. Now you can understand. Now the disposal of death is not a single incident, as you can understand. Alright. So now there are certain steps that you have to understand here. Now if this is the point of death, right? So now this is the final disposal, either in the form of burial or cremation. Alright. So now there are certain deaths where we should not have any death investigation, but there are situations where we should have death investigation process. During the death investigation process or inquest, again there are situations where you should not get any postmortem examination. But there are certain occasions where you get postmortem examination as well. Alright? Right. So now there are various types of postmortems, but here we are going to emphasize more about the first two groups. The first one is medical legal autopsy or judicial autopsy. As you can understand, Based on the law of the country, now there are um, two people who are responsible to have the inquest procedure, right? Now, according to the law of the, if a postmortem will be done according to the law of the country, it is termed medical legal autopsy or judicial autopsy. It helps to determine the cause and manner of death and identify the deceased. Conducted in cases of violent, suspicious or sudden deaths, or deaths without medical care or during surgeries, as you have learned during the part 1. Remember, there are certain other postmortems where this kind of postmortems will be done not based on the law of the country but because of the interest of the treating doctors. Imagine a doctor needs to know the pathological condition or more details or for research purposes, right? So in these occasions also a doctor get the possibility of having a postmortem examination. As name says here, such kind of postmortems are named not as judicial postmortem or medical legal autopsy. Instead, it is termed pathological autopsy. It is because of the interest of the doctor concerned. Alright. However, there are lots of differences in between these two groups. Pathological autopsy actually is performed not to diagnose anything. Alright. Now, to get the pathological autopsy approved, now the cause of death should be known. However, in case of medical legal autopsy, sometimes we are going to do the postmortem to find the cause of death. Instead, in case of pathological autopsy, the cause of death should actually know before performing the pathological autopsy. And the second one is, now doctor should get the consent from the next of kin or relatives. And also, now you are doing it because of your interest. As a result, you have to release the dead body as soon as possible. Alright. So now you are going to open the body cavity that you are interested in. So you are not going to open the total body just in case as a medical legal autopsy. Alright. So now it is only a pathological interest, as you can understand. Right. The third type is, and third one, virtual autopsy or medical imaging. Here, nobody is going to do the postmortem. Instead, they use MRI and CT technology to investigate certain things. So that's why it is termed virtual autopsy. Nobody is going to open the dead body, but still they can give the cause of death in developed countries. Fifth type is verbal autopsy. Here again, nobody is going to open the body. However, they are going to gather information based on other symptoms and history and everything. Alright, so it is just a verbal type. As you can understand during the COVID-19 pandemic, right? So we followed this system. Just we get a good history, medical records, contact history and everything, right? So finally come into a diagnosis, right? Because as you can understand, it was a threat to open a dead body. All right. And then sixth one is psychological autopsy. Actually speaking, verbal autopsy and psychological autopsy, basically there are lots of common points. However, one of the most important point is psychological autopsy will be done by a mental health personnel on his emotional state. That means more or less for suicidal deaths, if I tell you, right? So used in suspicious deaths, particularly in suicides, to assess the psychological factors by a qualified person. He is going to again think about the history, clothing, self-inflicted injuries, clinical records, witnesses' accounts and everything. Again, it's a type of verbal autopsy, but will be done by a qualified person. Right. Now we are going to compare the first two types which are important for us, judicial postmortems and pathological postmortem. As you can understand now, as name implies, judicial postmortem will be held because of the requirement of a country. However, pathological autopsy will be done not because of the law of the country but because of the interest of the doctor concerned. Alright, now who is going to do the postmortem? Now, as you can understand, judicial postmortem will be done by a JMO only. That means judicial medical officer or forensic pathologist. Instead, pathological autopsy will be done by a pathologist. It's not our duty or a JMO's duty to perform a pathological autopsy, as you can understand. So it's their interest. They want to do it. So they are going to do the pathological postmortem. And what are the objectives of performing a judicial autopsy? As you can understand, the objectives are very important here to find the cause of death, manner of death, time since death, to identify, etc., etc. In other words, to find important medical legal issues. Instead, here in case of pathological autopsy, objectives are not to find cause of death or anything. Alright? Instead, it is due to research purposes or for educational purposes only. Here, as you know, to order a pathological autopsy, first of all, we should know the cause of death beforehand. Very similar to the judicial postmortem, involved deaths, the doctor concerned should write to the director of the hospital first of all to get the authority for pathological autopsy as well. Any guesses or any explanations? Here is the reason. Imagine if it now the diagnosis was made already, right? Imagine by opening the dead body, now there is a great risk to the society. Imagine. However, the doctor concerned needs to see the pathological state on his own. However, without thinking much, if he happens to open the dead body, what will happen to the society? There will be contamination. Alright. So as a result, before having any pathological autopsy, the doctor concerned should write to the director requesting authority for that. Then director is going to think about the circumstances or any risks and things, right? So by having pros and cons, he authorized to have the pathological postmortem ahead. Now he has the authority not to give the consent to continue the pathological autopsy. Right. Now, as you know, the judicial postmortem will be done to find the cause of death most of the time. But here, cause of death is already known. Do you think that consent is needed in case of judicial postmortem from relatives? No, not at all. It's a legal condition. Alright, so we all have to obey the country's law. As a result, if there is an indication to do the inquest and also postmortem, the consent of the relatives actually is not needed. However, in this case, yes, we should get the consent beforehand over the BHT as informed consent. In judicial postmortem, we basically follow the proper dissection technique. That means we have to open all body cavities step by step. We have to cut open all the organs. However, in case of pathological autopsy, a full postmortem is not required. Instead, they dissect the desired body cavity or organ. Whatever the sample that should be taken in case of judicial postmortem, they are going to write over the postmortem report. In case of pathological autopsy, as a rule, they have to write each and every sample that they are going to take over the BHT. Now, postmortem report or the what the JMO is going to write over the postmortem report is a valid document in court of law. Here, during the pathological postmortem, they are going to write it over the BHD. Now, it's not basically a evidential part of evidence of the court, because they are doing it for their interest. There is no strict time limit to finish the postmortem, but has to be finished as early as possible in judicial postmortem, because there may be certain requirements that we should get before finishing the cause of death. Example, scene photographs. Imagine now there is a delay in getting the scene photographs or scene visit. We can postpone the the postmortem examination for a while. However, it should not be happen in the pathological postmortem. We have to finish it as early as possible, and we have to hand over the dead body with the respect. So now these are the basic differences. It's time to practice, to do the practice MCQs now. Right, which of the following is true or false regarding inquest in Sri Lanka? A death doesn't always require an inquest. Yes, it's true. There are certain instances where cause of death is very clear, no suspicious circumstances are there, right? Correct. Police hold the inquest. It's incorrect, right? Police is the section that they are going to collect relatives and inform and to do the first things, but holding of the inquest is not a duty of the police, instead a duty of an ISD or magistrate. Judicial medical officer is considered as an inquirer. No, there are two inquirers basically, ISD and magistrate, so it's incorrect. All cases of homicides need an inquest, definitely correct according to the law of the country. Postmortem examination is essential in all inquests, again false. I have explained that there are instances where inquiry into sudden death. For the investigation of death, consent of the next of kin is necessary. It's incorrect. Alright, so it is the law of the country. So we all have to obey the law of the country. So we don't have any choice. We have to obey the law of the country. Instead, in case of pathological autopsy, yes, we have to inquire about the consent of the relatives. ISD is authorized to go to the scene according to the law of the country. Yes, definitely. It's a fact. He has to go. Inquirers have to hold the inquest. Yes, true, correct. A natural death occurred at a prison can be released without having an inquest. Again, false. According to the law of the country or the inquest law, it is a must to have the inquest if it is a custodial type of death. An inquest is mandatory for death within 24 hours of admission, even if the death is natural and cause of death is known. It's incorrect. Now, people believe that we have to have an inquest, though we know the cause of death, manner of death, and death is not suspicious, if the death occurs within the 24 hours of admission. It's incorrect. Earlier, it is said that there was a law like this. However, now it's not applicable. Imagine patient admitted, right? So there are lots of ST elevation changes, and now we know it's a very clear-cut acute myocardial infarction. So in this case, if death occurs within the first 2 hours, no suspicion is there and no other doubts and anything, so we can give the declaration of death form or the cause of death. A house officer provides the declaration of death form when a person dies due to road traffic accident or injury. What do you think? It is incorrect, right? There may be situations where you know the cause of death, even the death occurs due to road traffic injury. However, you can't write the declaration of death form, even though you know the cause of death, since the instance is required to have the process called inquest. A house officer is allowed not to participate in inquest procedure, indicating that he is busy with ward admissions. Here, ward admissions. What do you think? He can't deny. So he has to go. As you can understand, inquest procedure is the law of the country. So as a result, he has to manage other parts, and also at the same time, he has to participate in the inquest procedure. The inquest procedure is written in the Penal Code of Sri Lanka. It's incorrect. It is written in the Criminal Procedure Code. It's a procedure. ISD is allowed to release dead bodies without post-mortem examination. Yes, examinations. Yes, it is correct. ISD is not expected to mark injuries since he is not a medical doctor. It is incorrect. Inquest law, it is clearly mentioned. Alright, magistrate and ISD should mark all the injuries. When an inquest is to be held, an intern medical officer is not permitted to write the probable cause of death or the cause of death on the bedhead ticket. It is actually incorrect. The reason is, now by using the BHT only, we judicial medical officers get clues about the cause of death of the death's concern. So it's no harm in writing your probable cause of death or the cause of death if you know already over the BHT, but not on the declaration of death form. Got the point? Right. Pathological autopsies are performed by JMOs. It's incorrect. It is performed by any other doctor or a pathologist. It's not our duty. It is the duty of the JMO to order the method of disposal, whether to bury or to cremate a dead body. No, it's not our duty. Actually, it goes to the magistrate or ISD. Alright, and also I can explain it as, right, so now relatives can request their way of disposal. We like to cremate the dead body like. Alright, so they can request by considering the instance, if it's a case of homicide or any suspicious kind of death, right? So nobody is going to allow to cremate the dead body because there is no way to exhume a dead body again. So we are going to have a chance to exhume the dead body. So as a result, there are certain instances where you don't get the chance to get cremated dead body, right? So whenever there are suspicious kind of situations or case of homicide, right? So you can understand the fact. The area Grama Niladhari frequently releases the bodies of young deceased individuals. Totally incorrect, right? So he can only release very old and the cause of death is known, maybe malignancies, right? So suffering for years, all right? So he can release or he can report to the area births and deaths registrar by having his idea about his form, all right? Otherwise, he can't release young dead bodies, right? Police are to be informed before performing a pathological autopsy. No, it's incorrect, right? Only judicial postmortems are to be informed to the police. Pathological autopsies are to be informed only to the director. An ISD is allowed to give an apparent cause of death. Yes, it's true. It is mentioned in the inquest law. Magistrates are not visit the crime scene in order to have the inquest. It's incorrect. He has to. Maternal deaths are released without an inquest if the cause of death is known. It's again incorrect. Now, based on the certain health ministry circulars, it's a must to have an inquest and also the post-mortem examination, even though we know the cause of death. Hospital director holds the inquest. It is incorrect. As I have explained you earlier, inquest will be held only by ISD or by the magistrate. Inquest for deaths due to animal bites are done by magistrates. It's incorrect, right? So it is done by the inquiry on deaths. A ward consultant is allowed to perform the inquest when death occurred under his management. What do you think? It's again incorrect. He don't have any permission according to the law of the country to have the inquest. State superintendent is perform the inquest in his state. Again incorrect, right? So he can inform about the death to the birth and death registrar. So it is the only duty that he can perform, but not the inquest. Pathological autopsy is done by using all the special dissection techniques. Again incorrect, right? So it's okay in performing to have minimal disturbances, or cosmetically you have to preserve the dead body during a pathological autopsy and as well as in the judicial autopsy as well. However, it is not required to have all special dissection techniques. However, in case of judicial medical autopsy, if a JMO is actually is failing in performing all special dissection where it is required, or he is going to do a halfway job, now it is a kind of medical negligence. All the postmortem findings are to be entered on the BHT in judicial autopsies. It is incorrect, right? So in case of pathological autopsy, they have to enter everything over the BHT. In case of judicial medical autopsy, we have to write about the cause of death, but not all the details. We are going to enter our details on the postmortem report. Consent is essential before performing a pathological autopsy. Yes, definitely. A known cause of death is not a prerequisite as it will find during the pathological autopsy. Again, incorrect as you can understand.